hopefully we'll get a good hearing tomorrow. Hopefully we'll get a decision from the court as soon as possible. And hopefully we'll be able to persuade Justice Phelan in the Allard case in BC to wait for the decision from this court, because that's going to set the guidelines and the goalposts from the highest court in the land as to Section 7 of the Charter and Section 1 of the Charter. As you know, we've been plugging away in Vancouver for 3 weeks anyway, in terms of the Allard case. So far, so good, we think. We still have a lot of work to do. We've got all kinds of arguments. We have deadlines, with the ultimate one being April 30th and May 1st are the oral arguments. And then the judge will get the case and he'll make a decision. How soon he'll make a decision, who knows. We've been trying to figure out how tomorrow's case will fit into it, but certainly we'll want him to wait to hear what the highest court in the land has to say about this issue, because it'll be the first time that the Supreme Court of Canada gets to deal with a medical marijuana issue.
Yes!
In Parker, the Supreme Court of Canada did not grant leave. In Hitzig, the Supreme Court of Canada didn't grant leave. In Murdoch, just a couple of years ago, the Supreme Court of Canada didn't grant leave. So here, they've had to hear it because it's a criminal case, and one of the judges in BC dissented. So that gives the government, the Crown, an automatic right of appeal. So that's why, for the first time, the Supreme Court of Canada is going to deal with this issue. And in dealing with the issue, they're going to have to decide what the ambit and scope of the Section 7 right is arising in a medical marijuana context. And they're going to have to decide what Section 1 of the Charter does. Section 1, by the way, is the section which provides that anybody who wants to limit a charter right, it's usually the government, has the onus of proving that the limit that they want to impose on your charter right is a reasonable limit prescribed by law that is demonstrably justified in a free and democratic society. And that's what we say this case is really about. It's about an attempt by the government to limit the patient's choice to use any form of marijuana. We say that the constitutional or the right, so that you're not put in a position where you have to choose between your liberty on one hand and your health on the other, means that you can use cannabis in any of its forms. And it's the government that wants to limit you in that regard. It's the government that came up with dried marijuana. It wasn't the courts. The courts said marijuana. So to put that in the framework for you. So if the highest court in the land has to make that decision in relation to non-dried forms of marijuana, that is going to be very important in Allard, because in Allard, we basically say the same thing. All the stuff about mold and fire and public safety and all that stuff is all Section 1. It's all about an attempt by the government to try and justify a limitation on the patient's right to choose their medical situation and what form of the medicine to use. And we're going to get to hear the government's case. And most importantly, we're going to get to hear what the judges asked the government lawyers. And that's going to give us some indication of what they're thinking. Because don't for a minute think that they haven't read, or their clerks haven't read everything, and they've have been thinking about it. This is their opportunity to hear what counsel has to say and to give us questions so that we can answer, hopefully, all of their questions to their satisfaction and hopefully, find in our favor. So We'll be listening carefully to what questions they pepper the Crown with. Hopefully that'll give us a good idea of what their concerns are. The Crown will get to speak for an hour. There may be a bit of a break, and then Kirk will get up and speak for an hour. Might be another little break, not sure. It's totally up to the Chief Justice. And then we've got a bunch of interveners. Unfortunately, the interveners have only been given about 5 or 10 minutes to speak each. But Canadian Civil Liberties Association is there with us.
Yay.
BC Civil Liberties Association is there with us. The Criminal Trial Lawyers Association. Very good intervener factum that they've submitted. The HIV/AIDS legal network is also there. Cannabis Santé clinic from Montreal. Now, unfortunately, they made a good intervener factum submission, and Julius Gray, their counsel, will be there, but hasn't been given an opportunity to speak. The same, I think it was the HIV/AIDS network. So they won't have anybody there, but their written submissions are in. But BC Civil Liberties, Jason Grattle, Andrew Locan, I think, for Canadian Civil Liberties, all great submissions. And one of the big questions, of course, is going to be what remedy? We're in this odd situation where the case was won at the trial level, and the judge struck out the word dried from the regulations, so that at least in British Columbia, everybody was able to use extracts pending the appeal.
Yes.
Unfortunately, the appeal court, while upholding the decision of Justice Johnson, didn't agree with his remedy, said that was legislating. Normally it's up to Parliament or the legislature, and said, the thing is, you find it unconstitutional, you give them a certain time to try and fix it out. So that's what the Court of Appeal did, but in the result, it's as if our remedy of being able to use extracts disappeared because they didn't create an exemption pending this court. So we're in this odd situation where we have to try and convince this court that really this isn't one of those cases where you give the government a lengthy period of time to try and fix things up. This is a case which calls for an immediate remedy. And hopefully one between now and their decision, if we could somehow persuade them to do that, because it's the patients, even though this isn't a case about patients directly, it's all about patients. It's about Owen trying to provide other forms of cannabis for the patients. So it's really about the patients. And it's the patients that need access to these other forms. So that's one of the problematic issues. Hopefully we'll get a good hearing tomorrow. Hopefully we'll get a decision from the court as soon as possible. And hopefully we'll be able to persuade Justice Phelan in the Allard case in BC to wait for the decision from this court, because that's going to set the guidelines and the goalposts from the highest court in the land as to Section 7 of the Charter and Section 1 of the Charter. If Justice Phelan doesn't wait and he makes his decision, hopefully he'll accept our evidence and our arguments and come to the right conclusion. But then if there's a decision from the court afterwards, the highest court, who knows how that might impact things. If it's consistent with our arguments, then great. If it isn't, it's going to create a problem. So the best thing is to get the Supreme Court of Canada to make its decision, and hopefully that decision will be so clear as to the ambit and scope of Section 7 and the role and the failure on the part of the government to justify any limitation, so that maybe Allard will become moot. That's my most optimistic thing. Because if the highest court says these are the rules, Justice Phelan has to follow them, he's bound by them, and we think our evidence is pretty clear in terms of the Section 7 violations. So, big day tomorrow. Hopefully we'll persevere and bring this government to its senses. Thank you very much.
John Conroy.